sharp as obsidian, cutting through the lies. Heavy boots stomping on corruption in disguise. No more cash for kids, we're blowing up the schemes. From the swamps to the courts, dismantling their dreams. We rise, fist high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Coward suits, sticky fingers in the till. Eviction notice served, we bending iron will. Paper trails, burning fire sparks the night. Shadow lurking, leeches bout to flee the fight. Polluted waters run deep, but we purify. Cleaning out the sludge, leaving no alibis. Obsidian sword swing, heads roll clean. This a reckoning, felt but never seen. We rise, fists high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light. But we the burning light. We rise, fist high, no justice, no peace. Cleaning out the swamps, unleashing the beast. You can't buy the future, leave the kids alone. Truth prevails with force, we reclaim the throne. Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light. Light, 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 Corruption's clock ticking, hear the final toll. No handouts, no buyouts, we devour the mole. Seeds of revolution buried deep within the night. Darkness on the horizon, but we the burning light.
Good evening. Got a little something for you tonight. We hold these truths to be self evident that all men and women are created equal. They are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effectuate their safety and happiness. I give to you Article 4, Section 1. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 3, Section 2, the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. But when not committed within any state, the trial shall be at such place or places the Congress shall by law have directed. Article 6, Clause 2, the Supremacy Clause. This Constitution and the laws of the United States, which shall be made in the pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or the laws of any state to the contrary is notwithstanding, meaning notwithstanding in law. The Ninth Amendment, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The 14th Amendment, Section 1, states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property. Aren't your children your biological property? Don't you have the fundamental liberty interest in directing the care, custody, and upbringing of your human offspring under Washington versus Glucksburg and Choxel versus Granville? Don't you got the right to life to make an honest living how you deem fit, not how some corporate government structure deems fit that you should do for yourself? Okay? Without due process of law, meaning they have to explain to you the charges being held against you. You have to have been served. There has to have been opportunity for you to actually reply in a court. They cannot just continue court without you because you didn't show up. It's not how that works. Nor deny any person within its jurisdiction the equal protection of the laws. Article 6, Clause 3, Oath of Office. The senators, representatives, all civil officers, they all take an oath. And all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as qualification to any office of public trust under the United States. So they are a trustee. And when they come calling you a sovereign citizen because you say they're a trustee, they're wrong. They're a trustee. Okay, they're entrusted to protect you. All governments were made to be a security, benefit, and protection of your rights. See Declaration of Independence. See preamble to Constitution of the United States. No matter which one you want to pick up. Okay, so here we go. This is for you CPS folks. Intimate association, First Amendment. Congress shall make no law respecting an establishment of religion, The religion is supposed to be decided by the father according to the Supreme Court, or prohibiting the free exercise thereof. So when they require and demand that you go down there for child support, to these child support hearings where they're subjecting you to 42 USC 666, and that's being done by the 42 USC 616. That's the mark of the beast and the number of his name. Okay, and that's 4 and 2 is 6, and then I and 6. Yep. Um, so that's a violation of your religious liberty to force you to attend a child support hearing. But back to the matter at hand for CPS. Or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Okay? I watched a man trying to petition his government for redress of grievances. I watched him get 7 knees in the back from police officers who showed up in force for him trying to exercise his constitutional right to ask his government for redress for stealing his children. They stole them. Or of the people to peaceably to assemble. Okay, you got the right to associate. You got the right to not associate. Okay, that's both intimately and expressively. So expressively would be you got the right to express that the fact that you don't want to associate with the child support agency, or you don't want to associate with the child support agency, or the CPS agency, or any of these other alphabet groups. You got the right to not associate with them, both expressively, and you got the right to your human offspring, both intimately and expressively. Intimately being the private realm of family life, and expressively being the public. Okay, moving on. Okay, and to petition the government for redress of grievances. While the previous sections that focus on expressive association, the Constitution also protects certain form of intimate association. These protections primarily extend from the personal liberty interest protected by the Due Process Clause of the 14th Amendment, which the court has construed to include an implied right of personal privacy. Okay. The relationships entitled to this sort of constitutional protection are those that attend the creation and sustenance of a family, including those formed through marriage, childbirth, child rearing, cohabitation with one's relatives. That'd be grandma. Okay. Fourth Amendment searches and seizures the right of the people to be secure in their persons, houses, and papers, and effects against unreasonable searches and seizures should not be violated. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. The concept of probable cause is central to the meaning of the warrant clause. Neither the Fourth Amendment nor the federal statutory provisions relevant to the area define probable cause. It's entirely a judicial construct. An applicant for a warrant must present the magistrate facts sufficient to enable the officer himself to make a determination of probable cause. In determining what is probable cause, we are concerned only with the question whether the affiant, where's the affidavit, had reasonable grounds at the time of the affidavit that the relief of the law was being violated on the premises to be searched, and the description and apparent facts set out the affidavit are such that a reasonably discreet and prudent man would believe that there was a commission of the offense, or that the offense was just, and therefore probable cause would warrant. Okay, so the Eighth Amendment for your child support people prohibits the imposition of fines and fees that are grossly disproportionate with the severity of the offense. 14th Amendment prohibits incarceration for non-payment of fines and fees without first conducting an ability to pay determination, establishing that the failure to pay is willful, because you got to have intent, because that'd be criminal. Okay, and this started out as a civil matter, which makes that quasi-civil, quasi-criminal, which is a quasi-jurisdiction. They're also quasi-legislative, executive, and judicial, which makes them a violation of the separation of powers doctrine, but we won't get into that. The 14th Amendment prohibits the imposition of fines and fees that create conflicts of interest. Okay. The 14th Amendment requires the consideration of alternatives before incarcerating individuals who are unable to pay fines and fees. Okay. The 5th and 14th Amendments require due process protections such as access to counsel in appropriate cases, as well as notice and imposing fines and fees. The 5th Amendment secures that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or in the militia when actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's the just compensation clause. The 6th Amendment securing that in criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, which means no, you don't get to hide it. You don't get to hide behind First Amendment gag orders on freedom of speech, on recording your criminal activity taking place in your courtrooms, Maine. You're not going to comply. Okay? Well, you're going to comply now because I have the constitutional right to sue you and report you for your abuse of your citizens. You sure you're going to let men play in women's sports still? Moving on. Okay. The 6th Amendment securing that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. And speedy meaning they don't get to time bar your stuff. They don't get to, drag it on, drag it out. Okay? By an impartial jury of the state and the district wherein the crime shall have been committed, which district shall have been previously ascertained by law. Informed of the nature and the cause of the accusation, the nature and the cause of the accusation. What is the intent? That's correct. They have a fiduciary duty. It's also called your constitutional oath of office under 5 U.S.C. 3331. That's the fiduciary duty and obligation. Yep, you're correct. Okay, moving on. 7th Amendment secures that in suits of common law, where the value in controversy shall exceed $20. Okay, so the right to trial by jury shall be preserved. Okay, so that's your 6th and 7th Amendment rights to trial by jury, and in child support, they take that away by statute just because it's a establishment of paternity proceeding. Except for it's not all civil, it's quasi-civil, quasi-criminal, because they start charging you with criminal stuff in child support when it started out as a civil matter, which is a blatant violation of jurisdiction, which means they do not have it, right? So the 8th Amendment secures that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. Isn't taking your children, isn't that I would consider that a cruel and unusual punishment, wouldn't you? Well, warranting that the fact that they don't have any valid evidence supporting their claim in a lot of these cases, and a lot of the stuff that they do have, it's made and generated by AI and computers, and you can tell it's real easy. Okay, so you're gonna. I need somebody to come in and to attest the validity of this document. I need somebody to tell me that this document is not a forgery before I can accept it. I can accept for value any criminal charges in the charging instrument, and make my exemption principle for offset of the charges against the defendant and release the order of the court to me immediately. Okay, moving on. 9th Amendment secures that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. 13th Amendment, Section 1 secures that neither slavery nor involuntary servitude, this would be child support, except as punishment for a crime. It can't be a crime to not pay child support because that's an obligation. And under 42 USC 1994, imprisonment for a debt or obligation. That's all peonage, the forced labor. It's all uh, a, a law can't be valid if it violates another law. It's not how that works. That's not a law. And you can guarantee that's a violation of the Constitution somewhere and the Bill of Rights. Moving on. Okay, so you've got your involuntary servitude and you got your 13th Amendment clause. The 14th Amendment clarifies that neither the United States nor any state shall assume or pay any debt or obligation incurred in any aid or insurrection or rebellion against the United States, which under Article 4, Section 4 would be the de jure republic. Okay. Or any claim for the loss or emancipation of any slave. All such debts, obligation claims shall be held illegal and void. So slavery is prohibited on 13th and 14th Amendment. Child support cannot be calculated and measured. It is not a civil court. It is not a civil court. It is not a criminal court. Arrears is a debt. Okay. The non-custodial parent is not you. You can go ahead and look that up. Okay. No, stop. Let me respond to what you're saying. Don't talk over me. Okay. Arrears. Okay. That's a debt. Non-custodial parent is not you. The non-custodial parent shall provide his social security number to the agency pursuant to 42 United States Code 666 A3C. And according to 20 CFR 422-103D, social security numbers do not identify, they are the property of the Social Security Administration. And according to 42 CFR, it's 45 CFR, no, it's 20 CFR, my bad, 20 CFR 422.107, social security numbers are not an identifier of a human being. That's simply incorrect. It's not a civil court. Okay. It started out in a civil court, but it becomes criminal real fast. Okay. Owing money cannot be considered a crime. See 42 United States Code 1994. A public defender is not appointed mandatorily. And it's not a court order because you're not in a court. See 45 CFR 302.34. You are incorrect. Please get out of here with that. Try again. Okay. No offense. Not trying to be mean, but you're wrong. See here. If a child is separated from his or her parents based on insufficient evidence, the family's right to familial integrity and therefore the right to substantive due process under the 14th Amendment will have been violated. And I can show you that child support being calculated is irrelevant. It was never meant to be child support. In fact, that is a lie. That's perjury because in courtrooms all across the country, they call it child support. But Blessing versus Freestone and We Hunt versus Ledbetter and Corelli versus Hauser and United States versus Sage all tell you that it's not for children. It's for public debt recoupment. It is a form of debt collection. And the holding of any person to service of labor for the tender of payment of any debt or obligation in any state or territory, and the usages, laws, regulations, rules, codes, anything that supports peonage is void. And if you don't listen, okay, it's all void. Okay, child support is not a court. That's what I'm trying to tell you. An unconstitutional law is void. An executive branch officer from the Child Support Enforcement Agency, that is not a court. That judge is not a judge. That judge is a contractor. Okay? And going down there, you are going down into their jurisdiction and you are consenting to be forced into involuntary servitude in violation of the 13th Amendment because you consented. Okay? That's all I'm saying. I don't mean no harm or offense by that by any means. But child support is one thing I know pretty dang well. Okay. A lot of it comes from the manual of child support. It comes from the federal definitions and all that stuff. But we're talking about CPS at the moment. Okay. So, but it also involves child support. So this is for everybody involved in family courts. See what I'm saying? It's a violation of your rights because they have a financial incentive to keep the entire family engaged in court proceedings. They are taking bribes to ignore your rights and look the other way like this. Okay. Um, the 14th Amendment clarifies that neither United States, yeah, we already read that one. The 14th Amendment prohibits the imposition of fines and fees in a manner that intentionally discriminates against a protected class. If a child is separated from his or her parents based on insufficient evidence, it violates the 14th Amendment. First Amendment protects the right to petition the government for redress in all grievances. Article 4, Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, as long as it's not in violation of the Constitution. See Marbury versus Madison. And the Congress shall make by general laws and prescribe the manner in which such acts, records, and proceedings shall be proven effect thereof. Article 6, all debts, contract engaged into, entered before the adoption of the Constitution shall be valid after. But this is where you get into the supremacy clause. So that's the supremacy clause there. Talks about this Constitution and laws of the United States, which shall be made in pursuance thereof. Okay. And all treaties made or what shall be made under the authority of the United States shall be the supreme law of the land, and the judges shall be bound thereby. Okay. Just to remind them, the 14th Amendment, Section 1, no state shall make and enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, property. That's the due process clause of the 14th Amendment. Okay. Uh, the bribes, I can show you where I can show you where they issue the bribes. I can show you how much the bribes are. There's nothing to debate. I know everything there is to know about that program. I am completely 100% correct. If you're listening to anything else like that they're saying in their little sham proceedings, that ain't real law. You cannot have an administrative judge. Administrative law judges violate the Constitution. It's the separation of powers doctrine. Yeah. Article 1, Section 1, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. So, can you please tell me why there is anything called a state legislature anymore? So maybe Tanoa was a little bit correct on some things. But the members of the many state legislatures became part of the Congress. That's what the Congress is made up of. Article 2 of the United States Constitution establishes the executive branch. Okay. The president said we're going back to the Constitution. So they don't get to ignore the Constitution. They don't get to say the Constitution doesn't apply in their court, which they like to say. They like to say that the Constitution doesn't apply here. You don't have that right in my court. I'm sorry. You have an oath of office, don't you? If you don't, or you aren't willing to provide it, or you're attempting to call me a sovereign citizen for asking for it, you're gonna have a problem with me. You know what I'm saying? That's how you got to come at these people. They have stolen your children. Article 3, judicial branch. We got Article 3, Section 2, Clause 2. In all cases affecting ambassadors or other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and to fact. The original and judicial jurisdiction of the United States Supreme Court is all actions in which a state may be a party through subdivision, politic, or trust. This includes all state-approved subdivisions. What is that? That's a county. And or incorporated cities. What is that? A municipality. That's your local PD. Okay? Townships, municipality, there it is. Villages, edilio, yeah. Removing a child from a parent's custody violates the 14th Amendment unless the removal is one authorized by a court order. How can a CPS worker just ask a judge to rule a court order when you're not there? How can there be a court when you ain't there? How can it be a court when it's purely administrative? Okay. Or is supported by reasonable cause to believe that the child is in imminent danger or of serious bodily injury. Okay. So judges can't just order what your parental rights are. Those are constitutionally protected activities. And when they do that, they violate their oath of office. And when they violate their oath of office, they cease to be a judge. In child support, they were never a judge to begin with. 45 CFR 302.34 is a contractual, it's a cooperative arrangement, which is a contract for service of process, issuance of warrants for arrest, all this other stuff. Okay. And they agree to do so under the state plan. And under that state plan is color of law. And under that state plan, they deprive you of pretty much all of your constitutional rights. First, fourth, sixth, 7th, 8th, 9th, 10th. That'll be the 12th, or no, the 13th, 14th, and the 16th, because they get into taxes. Yeah, it does not apply in Canada. No, you're correct, John. In Canada, you want to look to your Canadian Constitution, which Canada does have, which actually, oddly enough, has most of what I'm talking about in it. You're going to find out that almost every nation of the free world operates like this, or is supposed to in theory. But we got some corrupt actors. Okay. Potential violations of constitutional rights when a social service worker and police officer demand entry into a home and removal of a child based. And these are copied and pasted. This is copied and pasted from government documents. People can't tell me I'm wrong. They can't come say I'm wrong. Why? Because this is what the government said. You should go tell the government that they're wrong, because they are. They can't be violating your rights. Right. So this is what the Constitution says. This is based on the Constitution here. Okay. So procedural due process under the 14th Amendment is implicated when a constitutionally protected interest is concerned, requiring meaningful notice and opportunity. The First Amendment protection of familial association is considered emphasizing the need for a compelling reason for interference with family relationships. Now, let me ask you something, John. In Canada, it's a Christian nation, correct? And according to Christian biblical theology, the government ain't supposed to be taking your children, because isn't it not true under the Christian theology that God doesn't take your first or second born anymore? If God won't do it, then how can the agency do it to you? That'd be against your religious liberty. Okay, core authority section. The liberty interest, this is where it's going to get steamy, guys. The liberty interest at issue in this case, the interest of parents in the care, custody, and upbringing of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. In light of this extensive precedent, it can now not be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. The problem there and is not that the Washington Superior Court intervened, but then when it did so, it gave no special weight at all to Granville's determination of her daughter's best interest. More importantly, it appears that the Superior Court applied exactly the opposite presumption. The Due Process Clause does not permit a state to infringe on the fundamental right of parents to make decisions about child rearing simply because a state judge believes a better decision could be made. That's Troxel versus Granville, Supreme Court case, 530, United States Supreme Court 57, that'd be 2000, year 2000. In a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberty specifically and specially protected by the Due Process Clause includes the right to direct the education and upbringing of one's children. The 14th Amendment forbids the government to infringe fundamental liberty interests of all, no matter what process is provided, unless the infringement is very narrowly tailored to serve a compelling state interest, meaning compelling to the conscience. Okay? That'd be Washington versus Glucksberg, 521, United States, Supreme Court, 702, 1997. Here, the fundamental right to raise one's human offspring is deeply rooted in American tradition. Okay? Washington versus Glucksberg was a case about physician-based suicide where the court ruled the right to physician-assisted suicide is not a fundamentally protected right. The prompt test in that case, although having different subject matter, applies in the instance of human offspring and custody instances, applies because the raising a human offspring is a right that is rooted in American tradition, unlike physician-assisted suicide. Therefore, the case law still applies and sustained for that fact. Yeah, I know, man. That's so sad. Very, very sad. I never liked that guy, man. I never liked that guy. That's true. It can be the other parent that has brought the evidence of danger to the court, which gives a court order. That would be valid. That would require swearing under oath. That would mean if you can find discrepancies in that original affidavit and they have to provide you with it, if you can find factual inconsistencies, that if you can rebut the entire affidavit, it won't stand as true. Okay. And other than that, also another thing here is that false allegations get used a lot. Okay. And false allegations is not a right to revoke your parental rights. You don't get unequal custody. That's not how this is going to work. The only way that you're going to get unequal custody in a proper world would be if you really abused your children. And if you have, I don't have any remorse for you. Moving on. The best interests of the child, a venerable phrase among familiar divorce proceedings, is a proper and feasible criterion for making the decision as to which of two parents will be accorded custody. But it is not traditionally the sole criterion, much less the sole constitutional criterion for other less narrowly channeled judgments involving children, where the interests conflict in varying degrees with the interests of others, considering the other parent. The best interest of the child is not the legal standard that governs parents or guardians' exercise of their custody. And we're not talking about guardian ad litem. We're talking about grandma or auntie or whoever has temporary custody of the child because you've fallen on bad times and you don't want CPS to come knocking down your door. Okay? The best interest of the child is not the legal standard that governs parents or guardians' exercise of their custody, so long as minimum requirements of child care are met. The interests of the child may be subordinate to the interests of other children or indeed to the interests of the parents themselves. Reno versus Flores, 507 U.S. 292, 1993. And my ex will have people believe that her children come first always. I'm sorry, that is just simply not true. You are beating a dead horse with that argument because, in fact, she did the opposite. she did something that I'm not going to get into it because that's sensitive information. I won't. I'm not willing to get into controversy, but I will just say the only time I've had to talk to CPS is because of somebody else. That's what I'm going to say. And that person would be the OBGYN at the hospital. The fundamental liberty and oh, you should turn my X in, by the way. Yeah. The fundamental liberty interest of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents or they lost temporary custody of their child to the state. Even when the blood relationships are strained, parents retain a vital interest in preventing the irretrievable destruction of their family life until the state proves parental unfitness completely. The child and his parents share a vital interest in preventing erroneous termination of their natural relationship. Santosky versus Kramer. That'd be 455 US 745, 1982. And I'm going to say this. Just because you pay child support, that cannot, that this case law states that that cannot be used to deem you unfit to parent. Another thing about child support is when you go down there and apply for child support services, you automatically waive your right to the collection of child support over to the state because you don't have a right or a title to 4D services. You're not entitled to it. That'd be Blessing versus Freestone, We Hunt versus Ledbetter, and amongst other things. The custodial parent is being tricked. They consider you a custodian, not a custodial as in having custody, a custodian as in cleaning up the mess that you've created. Stop going down there. It's not good for your children. Okay. The law's concept of the family rests on the presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More important, historically, it is recognized that the natural bonds of affection and parents to act lead parents to act in the best interests of their children. The statist, I think, sadist, in my opinion, notion that governmental power should supersede parental authority in all cases because some parents abuse and neglect children is repugnant to American tradition simply because the decision of a parent is not agreeable with the child or because it involves risks does not automatically transfer the power to make that decision from the parents to some agency or officer of the state. Parham versus J.R. 442, United States, 584, 1979. We have recognized on numerous occasions that the relationship between parent and child is constitutionally protected. We have little doubt that the Due Process Clause would be offended if a state were to attempt to force the breakup of a natural family, Maine, over the objections of the parents and their children without some showing of unfitness for the sole reason for so to do was thought to be in the child's best interest. Quillian versus Walcott, 434, United States, 246, 1978. These are court decisions, man. The liberty, interest, and family privacy has its source and contours, which are ordinarily to be sought not in state law, but in intrinsic human rights as they have been understood. This nation's history and tradition. Smith versus Organization of Foster Families, 431, United States, 816, 1977. And you can guarantee that the foster family let that child go back to their original family. So you can't win. That's nonsense. That's all nonsense. It's all smoke and mirrors to get you to give up so that you never pursue the case that they don't want you to know that you have the right to sue. Okay? Our decisions establish the Constitution protects the sanctity of the family precisely because the institution of family is deeply rooted in this nation's history and tradition. It is through the family that we inculcate and pass down all of our traditions, morals, values, and cultures. Moore versus East Cleveland, 431 United States 494, 1977. This court has long recognized the freedom of personal choice in matters of marriage and family life as one of the liberties protected by the Due Process Clause of the 14th Amendment. Cleveland Board of Education versus LaFleur, 414 United States 632, 1974. It is cardinal with us the care, custody, and nurture of the child rests first in the parents whose primary function and freedom include the preparation for obligations the state can neither supply nor hinder. It is in recognition of that these decisions have respected the private realm of family life, which the state cannot enter. Prince versus Commonwealth of Massachusetts, 321 United States, 154, 1944. That goes for child support and CPS and adoption and foster care. You're all operating under state plans. That's color of state law. You're all depriving parental rights. That's deprivation of rights under color of state law. That's 42 United States Code 1983. Don't forget equitable tolling, service of process, and don't forget to ask some federal questions under 28 USC 1331 under proper jurisdiction, because your civil rights are involved. Or you can go to the Supreme Court, but they'll probably never take your case because they have what's called discretionary capacity. They take cases based on their discretion, not based upon obligation. Although they are obligated to the Constitution. Santosky versus Kramer, the court declared unconstitutional a New York statute. What is an unconstitutional law? Void. What is it void from? The beginning, which means what? Everything like it in all forms of law in the United States is void. Okay? That authorize the termination of parental rights based on a preponderance of the evidence. Santosky is a Supreme Court case that holds that even that after parents are found unfit in a contested court proceeding, they contain their constitutionally protected parental rights. I've had my baby mama tell me I'm gonna take your parental rights from you voluntarily or involuntarily. I said, you go right on ahead and try. You go right on ahead and try. It's going to be fair and equal as possible, no matter what. There are no exceptions. The only exception would be a child rapist or abuser who actually did it, and you've got evidence, like physical evidence, like where you catch him doing it or whatever, like that. Okay, that would be something that Santosky versus Kramer would not allow you to keep your parental rights for. Lassiter versus Department of Social Services, 452 United States, 1981. The court held parents have a due process right to a fundamentally fair procedure. Duchesne versus Sugarman. That's federal supplement. That's the federal district court. Still counts. 566, 817, 825, Second Circuit. 1977, the Second Circuit held the right of the family to remain together without the coercive interference of the awesome power of the state encompasses the reciprocal rights of both parent and child. The court explained that children have the constitutional right to avoid dislocation from the emotional attachment that derive from intimacy of a daily association with the parent. Stanley versus Illinois. 405 United States, 645, 1972. The court declared unconstitutional an Illinois dependency statute that deprived unmarried fathers of the care, custody, and upbringing of their children on the death of the mother without any showing of the father's unfitness. You know? Pierce versus Society of Sisters. 268 United States 510 1925. Relying on mayor, the court struck down an Oregon statute requiring children to attend public schools. The statute interfered with the right of parents to select private or patriarchal schools for their children. It lacked a reasonable relation to any purpose within the competency of the state. Mayor versus Nebraska. The court held that a statute forbidding the teaching of the German language impermissibly encroached on the liberty parents possess. The court explained the due process clause of the 14th Amendment protects the liberty incorporating the right to marry, establish a home, and bring up children. Where government action substantially interferes with fundamental rights, such as the right to familial relationships, it is subject to strict scrutiny, which means that the government must have a compelling reason for its action, and its means to achieve its goal must be narrowly as tailored as possible, although the government certainly has a compelling interest in protecting children who are in danger. The seizure of a child from his parents or the banning of all communication between them is not the most narrowly tailored means. Outside of the child seizure context, substantive due process can also be used as a sort of catch-all for constitutional violations. It applies when actions of a government official are so egregious, so outrageous, that it may be fairly said to shock the contemporary conscience. Like kidnapping. The right to procedural due process is implicated where a constitutionally protected property interest is concerned. Board of Regents of St. Colleges versus Roth, 408. Crux of procedural due process is the right to notice and an opportunity to be heard at a meaningful time in a meaningful manner, Fuentes versus Shevin. As a result, there can be no doubt that the 14th Amendment is implicated whenever the government seeks to separate a parent from his or her child, and due process principles generally require the right to notice in a hearing before children are separated from their parents, Hollingworth versus Hill. Separation does not have to be carried out with force for due process to be implicated. Instead, duress or coercion will be sufficient, such as trickery, where a social worker threatens to place the children in foster care if the children are not voluntarily placed outside the home with family or friends. Croft versus Westmoreland County Children and Youth Services. Dupuy versus Samuels Federal Supplement. Second, third, affirmed. Where there is reasonable suspicion to believe that a child is in imminent danger of physical harm, a pre-deprivation hearing is not required. Sorry, an unconstitutional law is void. Marbury versus Madison. Norton versus Shelby County. In such a case, several courts have determined that a post-deprivation hearing, there we go, uphold it, must be afforded within 72 hours, and even if such a hearing has not been requested by the family. Patterson versus Armstrong County Children and Youth Services. Would you look at that? Federal supplement. I'm going to keep going here. Man. In as much as every, okay. Wait. I'm skipping ahead. The 14th Amendment guarantees individuals the fundamental right to be secure in their persons against unreasonable searches and seizures by government officials. Several courts have held the removal of children from their home as a seizure implicated in the Fourth Amendment. Kovacic versus Cuyahoga County Department of Children and Family Services. Sullivan versus Indiana Department of Child Services. Hernandez versus Foster. O'Donnell versus Brown. County Department of Family Services. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind. Only a government can interface with only other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining any parity with the tangible. The legal malfeasance and manifestation is that no government, law, agency, court aspect can concern itself with anything other than corporate artificial persons and the contracts between them. According to the derivative explanations of the Penhallow versus Dones Administrators 3, United States 54. Page 93, statutes at large. It's in somewhere. If a man or woman relies in good faith on the advice of counsel or on the decisions of the United States Supreme Court, that man or woman has a perfect defense to the element of willfulness. And since the burden of proof of said willfulness is on the prosecution to prove beyond a reasonable doubt, said task or burden being totally impossible to specifically perform, there is no cause of action for which relief may be granted by a court of law. United States versus Bishop. Washington versus Glucksberg. A little bit of Marbury versus Madison. If a basic right and a law of any state to the contrary is such exercise of that basic right, that said supposed law of any state is a fictional law, totally 100% unconstitutional. Marbury versus Madison. Troxel versus Granville. Yeah. Holmberg versus Holmberg. There we go. Child support is not a judicial process, but an administrative tribunal. These tribunals have no appeal. The Minnesota Supreme Court found their statutes violate the separation of powers doctrine by allowing administrative law judges to modify district court support orders and permitted executive branch members to practice law. Therefore, the statute's unconstitutional. Marbury versus Madison. That's void. Norton versus Shelby County. Void from the beginning, wholly, entirely, completely, across the country. In We Hunt versus Ledbetter, the 11th Circuit ruled that plaintiffs could not maintain an action against the state of Georgia and the Department of Health and Human Services under a 1983 that the FBI will try to tell you is some sovereign citizen made up law, which it is not, which is actually defamation of character and perjury, and I have them committing it in a document. Have a nice fucking day. Okay? When I'm talking to the FBI on that. The 11th Circuit held that Title 4D does not create enforceable rights, and it does not address the issue of foreclosure, any of that. Yeah, it was not enacted to benefit children. It was to benefit the public recovery of funds dispersed under Title 4A and returning them to the federal and state treasuries. Ouch. Corelli versus Hauser. Same thing. State versus Clavel. We got peonage in here. United States versus Reynolds. Bailey versus Alabama. Canons of judicial ethics. It is the duty of all judges in the United States and of the states to support the federal constitution and of the state and of the laws of which they administer it that are not in conflict thereof. They should fearlessly observe and apply fundamental limitations and guarantees. Judges they have constitutional obligations. They must serve the public interest. They must avoid impropriety. They must show courtesy and civility to all litigants, clerks, etc. They must stop any unprofessional conduct of lawyers in front of them. American Bar Association. Courts have recognized that the First Amendment protects the fundamental right to intimate association, which includes a familial association between parents and children. Bar Association. The people taking your children are saying that they can't take your children. You know, this is some craziness here. Um, yeah, I'm out of breath. This gets it all into child support. But yeah, so to prove that deprivation of rights under color of state law, all you got to prove is that a state official or they acted under the law of the state or um, they acted under some sort of state plan with the federal government, which they did. You can find that under Title 42 United States Code, state plan for adoption, state plan for foster care, state plan for CPS, state plan for child support, state plan for Medicaid. They have to have one. And if they deprive you of your rights in issuance of any of that stuff, they are subject to 42 USC 1983, and Williams versus Reed says that the state can't block that. The 11th Amendment does not say, that states get immunity from lawsuit by a private person. It says that they get immunity from lawsuit from the federal government. 42 USC 1983 is not brought on behalf of the United States. Where the United States is not a party, the principle of sovereign immunity, right, should not be used and cannot be used to deny someone the constitutional protection of their rights. I mean, United States versus Lee, Butts versus Economy. Franconi Associates versus United States. When the United States involves itself in commercial paper, it waives its sovereignty. If the United States federal corporation waives its sovereignty when it involves itself in commercial paper, then so does the state. The state's a corporation. MI in all capital letters, that's a corporation. That's a legal fiction. Texas in all capital letters, that's a corporation. That's a legal fiction. These are all legal fictions. It's all corrupt. Incentive payments to states, you can find that for child support. You can find that to keep the entire family engaged in court proceedings. You can find that under child support. It operates the same way in Canada. It operates the exact same way. Your protections are going to be different, though. You're going to have to find those protections in your Bill of Rights. And Jonathan put that here in the comments section, I do believe. Right. So the thing is, I bet in Canada they're not allowed to just walk up in your home. I bet you that they're not allowed to do that. Look that up. That'll be your Fifth Amendment. Don't worry about the 14th. If it says 14th and you don't have the 14th Amendment, but you have the 5th, as long as you have a due process clause, every constitution has to have one. It is the crux of a constitution. Your Canadian Bill of Rights has got to have one. It must. Or you wouldn't have a government. All governments are artificial persons and creatures of the law only, and can only interact with other artificial persons in the contracts between them, donor administrators. That's Penn Howell versus Doan's administrators. It was a Admiralty Law prize case on the ocean. You won't find it referenced specifically in the case law docket of what explained, or the case decision docket, which explained everything. But you're going to find it and surmise it through what they were talking about. Go back to your Magna Carta. It's more powerful in Canada. It'll help you. So I had one more subject tonight to speak about, and then I'm going to go ahead and free associate for a moment. Gender affirming care. This is the Office of Population Affairs. Gender affirming care is a supportive form of healthcare. It consists of an array of services that may include medical, surgical, mental health, and non-medical services for transgender and non-binary people. Okay, it gets this is a document. You can find it over at Office of Population Affairs. It talks about gender diverse adolescents. Why do you have a gender diverse adolescent? You have a gender diverse adolescent because they think that their gender is not what they were born with because they were missing a parent to teach that to them growing up, and the other parent taught them this instead. There you go. There you go, buddy. You found it. It's in every country. So is this Title 4D beast. You got to start being the one for Canada to start teaching people. Now, I would start looking in Canadian court cases and start looking where your rights are protected by the Canadian court cases and learn how your documents are filed specifically in Canada as compared to the United States. You're going to find somewhere in your statutes there's a statute that protects your civil rights, and you're going to aim that at the agency. But not the agency itself, not the corporation. The person in their individual capacity with their all caps name, that corporation. That's the one you'll be suing. Gender diverse adolescents face significant health. Yeah, it gets into a bunch of stuff here. But what they're saying here is affirming care, social affirmation, adopting gender affirming hairstyles, clothing, name, gender pronouns, and restrooms and other facilities at any age or stage and is reversible. Puberty blockers, using certain types of hormones to pause puberty development during puberty. Reversible. No, it's not. Your puberty doesn't just come back. I mean, you could do some hormone manipulation, but you're gonna get sick. Hormone therapy, testosterone hormones for those who were assigned female at birth. You are not assigned a gender. You are determined to have a sex at birth. Your gender is a decision that you make. Okay? So, testosterone hormones, estrogen hormones, early adolescence, partially reversible. There's no partially reversible. It's either reversible or it's not. Now, keep in mind, taxpayers are paying for this. Gender affirming care, top surgery to create male typical chest or make breasts. Surgery on genitals or reproductive organs. Facial feminization, typically used in adulthood or case by case in adolescence, is not reversible. And that surgery, that bottom surgery, makes you sterile. You'll never have a kid again. And they're running around telling people that they can freeze people's stuff or all that. So let me ask you, why would we be having the discussion of confusion about gender? It wouldn't be because the family courts have removed fathers in the child support arena for the past 60 plus years, and they ran out of obligors of fathers to obligate. So then they started sending the CPS after the mothers and the families. I could show you where all their money's at, how they make it, how your rights are deprived, how to exact remedy. You take your criminal complaint, you take Title 18, you find crimes that these agents are committing, and you go ahead and turn them into the FBI and Department of Justice. And when they don't do anything, you turn the FBI and Department of Justice into the president. And on a child support, the Attorney General of the United States, Pam Bondi, is receiving a bribe under 31 United States Code 3720C because of the debt collection improvement account due to 42 United States Code 1994. This state's peonage is void for any debt or obligation. Yeah. And she's obstructing enforcement of the litigation of these cases of the deprivation of people's rights to this peonage under 1983, 42 USC 1983, 42 USC 1994. It goes into 18 USC 1581. Then we make another criminal complaint to her, complaining to her Department of Justice about her. Along with an executive order from the president that we were going to return to the Constitution. Why is the Attorney General of every state and of the United States accepting a bribe to look the other way on 13th Amendment violations of the prohibition on peonage, slavery, and involuntary fucking servitude? You know? Why is Maine trafficking children? You don't get to traffic children. You don't get to lie on court documents. You don't get to imprison people without due process of law. Habeas corpus. You don't get to do that. You know? And it's up to you to enforce it. You got to be the one. You got to go do it. Ain't nobody going to do it for you. I'm out here learning this stuff every day for all of you folks for a reason. People who hurt children are the people that I hurt. And I'm going to hurt them. It's coming. They don't know when. They don't know how. But they dang sure know why. You know how many tears men shed because they never get to see their child? And they get labeled indigent, obligor, asshole, all these other things, narcissist, you name it. These are all tricks. Misogyny and feminism are the agency's tools to get you fight amongst yourself. Sooner that you realize that, the sooner that you'll realize that the legal fiction, the all caps name, is not you. It is a corporation. However, you don't go in there telling them it's a corporation. They're going to label you a sovereign citizen, which is a label of a domestic terrorist term, which means somebody that we need to look out for because they really know the truth. And we really need to hammer it home to them, put them in federal, some sort of federal jacked up maneuver outside of a courtroom, unlawfully assaulting and trying, maybe even attempting to assassinate them. Maybe they're going to commit, maybe these fools want to come in and try to commit some 18 USC 1111. But I doubt they'd get past the lasers and the dog and the pepper spray and the taser. Bad Elk versus United States. I got the right to defend myself in any way, shape, or form. Second Amendment. I got the right to bear arms. What are arms? Arms are anything I could use to be defending myself. What could I be used to defend myself? That'd be a camera in the courtroom to record any mother that's violating my rights. Because because I arm myself up with my digital technology. Since they want to use weapons. How about this one? 42 United States Code 1983, civil action for deprivation of rights under color of state law. 42 United States Code, that'd be, it's 654, state plan. That's color of state law. That's proof of color of state law. The state submits a plan to the Department of Health and Human Services that they will comply with the department's rules and regulations when enforcing the child support program. That's color of state law. What rules and regulations are they enforcing? Well, that would be the 42 USC 666 statutorily improved procedures to enforce child support obligations. Okay. Statutorily prescribed procedures to, yeah. So that'd be 42 USC 666. And that's done by the 42 USC 616 federal actor. Okay. So it's a federal actor committing this. Okay. And they're doing it under the guise of being the state when it's initiated by federal. So that's color of state law. And 42 USC 666 is equivalent to the mark of the beast. And according to my religious liberty or freedom under the First Amendment, that's a deprivation of my religious liberty. And so 42 USC 1983 applies for deprivation of rights under color of state law. And they can't block it. Owen versus City of Independence. Butts versus Economy. United States versus Lee. So we've got Williams versus Reed 2025. We've got several others. And then ex parte Davis, any communication that they make with the other party outside of a court of law is void. And then you got Miranda versus Arizona. The constitutional right cannot be converted into crime, such as the right to be free from involuntary servitude under the 13th Amendment, which is being perpetrated by the 31 USC 3720C Attorney General due to the Debt Collection Improvement Fund, and they're issuing that under 31 USC 3720D wage garnishment, which is a form of forced labor by which an employer forces obligor / non-custodial parent to pay child support obligations, which under 42 United States Code 1994 is abolished. The imprisonment for anybody for debt or obligation, voluntarily or involuntary, directly or indirectly, it is prohibited in any state, territory, or possession of the United States. And any usages, laws, rules, regulations, establishing, so that'd be voluntary establishment of paternity form, are void, and any debt or for any debt or obligation. Child support is an obligation; it's a debt. They can't force your employer to force you to work, and if you don't work, they're going to issue a warrant for arrest and send you to jail. That's peonage. That is abolished. That is criminal activity. So no, child support is not calculated by state calculations, because child support is completely void from the very beginning, ab initio. And the one that it is enforced upon is the Social Security Administration, 20 CFR 422-103D registered property, the Social Security number, which it does not identify me as the 420 or as the 20 CFR 422-107 human being, but it does identify the obligor / non-custodial parent, which is not me, at 42 United States Code 666A3C. So it's a mistaken identity of the obligor, and therefore, under case closure criteria, under the law, it's there's a mistake in the identity of the obligor, so now no overdue support exists, so now the case must be closed. Yeah, and they're also private persons. Everybody who enforces child support is a private person under 42 United States Code 659 I-4 definition of someone who does not have immunity from 42 USC 1983 civil action for deprivation of rights under color of state law. I'll be asking for $250,000, and I want any and all orders that were issued in regards to my parental rights or any case within the state rendered null and void, ab initio, for lack of constitutionality on their face. I want to reprimand the other party. I want to make sure that that family court arbitrator that violated my rights in her private capacity, her name is Janelle L. Chala. Her bitch ass, yeah. Yep. You and Javier Becerra and Stephen Capps and Tangular Gray and Aaron Frisch and Patricia Risch and James Langford and all you you're all going down now. Because I'm going to sue every one of you because I've witnessed all of your unconstitutional abuse and I've had to witness it. And because I've had to witness it, I have the right to sue you for the violation of my right to not have to witness that under the 9th and 10th Amendments. States are prohibited from violating the Constitution. This is what I'm saying. But we need all the people we can get. And we need to be fighting now because the attack on the family unit is much deeper than you could ever imagine. They have had the education department underneath of their thumb. They've been educating our children that it's okay to feel that they're in the wrong body. A practice that just 60 years ago, we would have, or actually probably about 80 years ago now, we would have considered despicable, and we would have locked these people up for child abuse, right? But now we got the government sanctioning it, paying for it with taxpayer funds. And you're not upset about that? You're not down at these committee hearings and screaming at these people about your rights in mass droves in the hundreds? Probably because they incarcerated most of you non-custodial parents who are the ones with the balls to fight. They have just chopped your balls off out here. It is sad, bro. They have chopped your nuts off. Okay? They have cut them off. And anything that made you a semblance of a female, they've erased that. They want to make you a baby maker that makes babies for them so they can get the contract funding, okay, off of the back end from Planned Parenthood for experimenting on baby fetuses and all this other stuff. All this other disgusting stuff that I shouldn't have to know about, that I shouldn't have to prosecute. But somebody's going to prison, and it ain't going to be me. And it ain't going to be you. It's got to be them. And it's up to we the people to make it happen. We the people make it happen, Captain. This is America. Last time I checked, there's an American flag on almost every porch out there in the neighborhood. Yeah, we allow other flags to be here. That's because we come from everywhere. Contracts are void for non-disclosure. Look up the Uniform Commercial Code. I'm sure it operates in your country. Look up court cases that may have been won. Look up how your court system is organized, because I've looked up the Canadian court system. They have more protection than us. Don't think you don't. It's just you got to find it. They're hard to look for. In Britain, in the UK, the UK, it's not written. You got to use the Uniform Commercial Code on them, or some other sort of use their law against them, or something like that. That's all you're really going to be able to do in the UK. Because you have a sovereign. Over here, we don't have a sovereign. The United States is not sovereign. The states are not sovereign. Okay? A corporation cannot be a king. A corporation is not a living thing. It has no modus operandi. It has no corpus momentum. Nothing. Let me tell you what a mortgage means dead hand. It means your hand's dead, you're passing off your dead property to somebody else. You know that's supposed to be put in a real estate and investment management conduit upon closing, a REMIC account, and if they don't put it in there and they don't securitize it, then they're selling defaulted derivatives to their investors. Did you know that a traffic ticket is completely void? How about a marriage license? How about a driver's license? All of these things are unconstitutional. A state cannot convert the liberty of the freedom of movement and the right to travel into a privilege such as driving or going for a walk, right? For a fee, okay? They cannot license that for a fee. States can't do that. That's why the federal government is the one who issues gun licenses. Except for the federal government can't do that because shall not be infringed was quite clear, which is now well established within the executive branch because they're not having it. And who is the prosecutor? Who is the one that brings the cases, brings the charge, to be the plaintiff or the prosecutor? If the prosecutor says they're going to go by the Constitution and they do not, that's a problem. They're all public officials. They're all public servants. These are not public masters. These are not your masters. They don't have laws that you are obligated to. The only laws that you are obligated to are the ones that are positive law within the United States Code that do not conflict with the Constitution. If it conflicts with the Constitution, then Congress was out of line. Congress better get down here and figure out these 4D laws and stop obligating people, stop jailing people, stop sending people to jail, stop arresting people, stop taking people's children, stop taking people's firearms, stop taking people's property, stop throwing people in jail, stop putting bonds on people, stop fucking making securities that you don't have any fucking say in making. Stop impinging upon us with your Federal Reserve banks. Just stop. Stop firebombing Tesla dealerships. Just stop. Stop polluting the environment. It's not hard. You put a carbon filter on the tailpipe of every car and on top of every thing that emits carbon within every inner city limit, and you're going to have all the carbon collected. And then you make graphene technology with it, which makes far efficient solar panels that they won't allow because they limit the efficiency of solar panels to only 20% in order to keep us behind because it's the Green New Scam. Let me tell you, bro, there's so much stuff people don't even know about, man. Did you know the CIA interfered in every foreign government that has ever been called, supposedly they're called a free country? Out of here with that. Your freedom is yours to decide, not what the government tells you. As long as you ain't hurting nobody and their rights, they ain't got nothing to say. And women do not have a right to child support. Men do not have a right to child support. Okay? Men are not obligated to pay child support. Neither are women. The Social Security Administration is obligated to pay child support. But the actual obligor, believe it or not, is the one that is forcing the child support on you or enforcing it in any way, shape, or form. Because they have an obligation and a duty that they took freely without any mental reservation, okay, to support this Constitution. This Constitution. No other religious test shall there's no religious test, none of that. You know? And they just walk over people every day, man. That's correct. Why do you think I used the word prosecutor? Okay? Plaintiff, prosecutor. Okay? It started out civil. Child support is fucking criminal. They send you to jail. That's criminal. Just stop. Okay? You're not winning. There's no winning. There's no getting around it. I'm correct. I'm sick of people arguing that with me. Do not argue child support with me. There's a reason why you do not argue child support with me. Because if you're arguing with me, I'm going to say it again. You're arguing with the government. Go argue with them. Don't shoot the messenger. You know what I'm saying? This is not a civil or criminal matter. That's not what this is about. You're caught up in technicalities. It doesn't matter if it was civil or criminal. They did not have jurisdiction to begin with. So what the fuck? Enter an order. I can appeal that at any time. They don't see that. They just see all this other shit. Civil action to enforce the recompense of the violation of your civil right is a civil matter. Child support is not a civil matter. See 18 U.S.C. 228. This is not a fucking civil matter. I don't know if people told you, but child support cases are not cases. They don't have judges. They're not courts of law. It's all fake. I've already explained that to you tonight. And anybody out here doubting me, you can go look up everything I just said, and you can go find it, and you go argue with the government. Don't argue with me. Go argue with the government. Don't complain to me. That's what they said. You know what I'm saying? And no offense to anybody. I'm not mean to be any type of way. But you see, Marbury versus Madison, an unconstitutional law is void from the beginning. Norton versus Shelby County. How can you use both jurisdictions? You know? It's just not how that works. And they don't get to tell me I'm wrong. They don't get to tell me I'm full of shit. They don't get to tell you something else and drag you along and make you pay something to learn the information that's already free. They don't get to do all that. But I just really hope everybody gets their kids back, because we are tired out here, man. Tired of fighting. Tired of losing. '42 United States Code 660. Original jurisdiction, civil action to enforce child support order shall be in the district court. It would surmise under equal protection of the law that also applies if you want to seek that, which you can. It's also protected under the Equal Protections Clause of the 14th Amendment and the equal protection of the law under 18 U.S.C. 15. It's 42 United States Code 1981. And when they conspire against you, that is 18 U.S.C. 241. It becomes a 242. People will tell me you can't use 18 U.S.C. 242 as a private person because you are not a prosecutor or an attorney general,
and in which case I had already made a video where it expressly showed you how to file the document to file your criminal complaint to the DOJ, to the FBI, to the proper people to enforce the code, and people still want to argue with me and come tell me I'm wrong about something. You know, that's why I get upset about that. Is because they've been harassing me with it for about 3 months now, and I'm getting tired of it. 18 USC 242 does apply because they're committing 1581. Peonage. Or no, 1581, yeah. Peonage, obstructing enforcement. When they are blocking the enforcement of the laws of the prohibition against peonage, which is a form of human trafficking, which is what they do when they stuff you in a car with an executive branch issued judicial warrant and take you 3 counties away and stuff you in a jail cell for a week, after which point they tell you, oh, we'll let you go after you sit for 5 more days. Or whatever. Or you can go in front of a judge and he'll give you 45 days. That's threat and abuse of legal process. When they first contracted with me, this is all contracts. Contracts are void if they violate your rights, if they cause crime to be committed. They can't do any of that. No law can be made impairing the obligation of contracts. What does that mean? That means you can't make a law that stops a person from paying their debt. That's all that means. It doesn't mean that child support gets immunity from you know what I mean? It's the person's choice. It's supposed to be a right. Instead, it's a detriment. So you don't have to listen to it. It doesn't exist. So I keep trying to tell people, you don't have a child support case. You never had a child support case. It never existed at law. These CPS workers, they can all be sued for their crimes. And these federal judges are getting behind them. Those federal judges getting behind them and violating your rights can also be sued. They can be appealed. It's all an appealable issue. Then they got 3 judges looking at one judge, asking that judge why he's not judging correctly, which is all enumerated how they're supposed to deal with it under the judicial canon law. And that's canon's law. And their canon's law, they're acting improprietous. They're also depriving people of their First Amendment on some unconstitutional gag order telling you what you can and can't say or record in a public place, which is a crime. 18 USC 242 is a federal crime. And they will prosecute it if you bring it to them properly. In the United States, anyway. Not if you signed off on their waiver of your parental rights, but yeah, essentially, yeah, you're correct on that. I'm not saying that you called me out as wrong. You're putting words in my mouth, man. I never, no. I said people. Are you people? If the shoe fits, then wear it. If not, then keep it moving. That's what I do. But yeah, no, all of this stuff we're doing is completely unlawful. It's void. It's criminal. It's also civil. These are deep-seated matters that See, the family courts exist because you can't get along after you break up because you're both stupid. That's what the government thinks about you. You're both fucking dumb. You can't get along. And that's why they've come to harm you. That's what they think. Because everything they're doing and everything they're saying in court is completely 100% incorrect. They're basing everything off of state court proceedings that have no force and effect against federal court, citations. So I don't care what people say. I don't care what people think. I don't care what people do. I'm just out here educating people. And if you don't listen, that's totally on you. You don't have to. I'm just telling you what the law and what the facts say. That's all I ever do. And the fact is and remains, your constitutional rights are protected, and they can't be stepping on them like this. When they do this, that's what the lawsuit's for. I don't, I never showed you guys my planties. My planties. I got some more outside. Yeah, I know nobody wants to deal with these people, but I don't know if you can see it. It's a little dark out, but no, nobody wants to deal with these people. And you shouldn't have to. Yep, correct. Because it's unconstitutional. That's correct. The removal of your parental rights is constitutionally protected. That's something that only you can waive by signing a waiver. It's also got a lot to do on the back end with Miranda versus Arizona, your Miranda rights, which they say aren't a right, which they say is a warning, which is a warning, because anything that you say to them can and will be used against you. And you shouldn't be answering any questions. You shouldn't be making any statements. The only things you should be saying are questions. And the only thing you should be doing is protecting your constitutional rights with those questions. And you're going to find that they got to turn around and leave. Consent. You let them in. You let them there. You let them do what they're doing. You don't speak up. You don't fight back. But the thing of it is, if you do, they come at you even worse. And that's what's so unconstitutional about all of this. Is disgusting. This is destruction of the family unit. We have more children homeless than ever before. We have more adults homeless than ever before. Look, when you're fatherless, you're more at risk for homelessness. You're more at risk for drug abuse. You're more at risk for criminal activity, gang involvement. You're more at risk for being involved with all of these things as a child. And then continuing on, usually mothers' parenting style, no offense to mothers. Mothers are great. We got to have them. We love them. We don't hate them. Us men who are being forced to child support, most of us do not hate mothers. There's a few of us that are very bitter, but that's bitter X stuff. And most of us aren't into that. We just want to be there for our kids. Now, that's not to say that there aren't exceptions to the rule where you get people who are abusive to children and they need to be separated from their children because they're devious. That's not to say that that does not occur. I probably could do some videos on the Canadian Charter. I'm not well established on my account enough to do lives yet or anything like that. And yeah. No, that's what I was talking about is your estate. When you sign your rights away, that's what you sign away. If you sign away your rights, you still have to pay child support. But your child doesn't get any of your trust or your estate or any of that stuff. Unless you specifically laid that trust out for them. Like your trust is your all caps name. That's your back in the day it was Smith. Smith. You'd go down to the smithy. Their last name was Smith because their family smithed things. They were blacksmiths. This is where this all came from. The all caps name and all that came in later. The Social Security Administration is a worldwide administration. It is not, I repeat, it is not exclusive to the United States. Yep. Neither is child support or the family courts. They're everywhere. All over the world. It's one world government. I'm telling you. It's one world government. I'm telling you. I'm calling it. No, but for real. I could do a whole thing on Canadian law. Look up Mr. Mighty. Mr. Mighty. MRMYTEE. And look up Free Man on the Land. That should help you out, bro. That should help you out a lot, man. Because these parliamentary governments, they are not as caught up with the free man movement as the United States is. In the United States, when we try to use any of this stuff at all whatsoever to defend ourselves, if we don't have a lawyer, we're called a sovereign citizen. We're called somebody who's rebelling against our government. It's disgusting. They treat you like a terrorist for trying to know your rights and trying to learn their laws. Isn't it disgusting? And then they come all over the internet defaming your character and committing perjury all over themselves because the president himself said that we the people are sovereign, not the government. You know who's really sovereign? God. God is sovereign. At least my God. You know, just because you don't align with my religious beliefs doesn't mean that I don't care to have you around. It doesn't mean any of that. It just means that, you know, me personally, I know that you're incorrect in your religious beliefs, but that doesn't mean that has to be. See, that's where Christians get it wrong. You go around persecuting other people for stuff you're guilty of yourself. Can't be doing that, you know. I know I've done things in my past that I regret, and well, the thing about Social Security death benefits wouldn't be part of the child support system because it'd be automatically paid out to the quote child. But if you look at the international intent of child support, it was not intended to benefit children. Look at that. It was intended to get rid of governments around the world their debt for children. It's a social welfare. Social meaning them. Meaning it's for their welfare, not for the welfare of your child, man. The IRS, Internal Revenue Service. Why is it operating externally upon people? Now we got the External Revenue Service coming up. But that's going swimmingly because we're getting sweeping across the board on Wall Street, deprivation of our entire fucking stock market because of Trump's tariffs. So we're heading into a fucking economic apocalypse because the other countries won't back down. But they'll start to. It's all about endurance with that. We should be more worried about making our products here instead of shipping them out elsewhere to do them somewhere where somebody's gonna, you know what I mean? You're shipping all of our money, our labor, our supplies, everything else to a foreign country, and then shipping it all back here after you make it over there. Are you kidding me? Just to ship it out again? That's dumb. That's the dumbest type of trade that I've ever seen. That was Joe Biden. That was essentially Joe Biden. Inflation Reduction Act. Man, the only reason we have debt so bad, so astronomical. Child support is considered a debt. You know how many obligors there are? You know how many hundreds of thousands of dollars are not paying? That all gets tacked onto the government debt that the government owes the people. And the government's got to pay the people back, but it can't let the people know that it's obligating the people to pay themselves back. It's a run on the bank. Incentive payments to states is a bribe. 42 USC 658A. Why is it a bribe? Because the word incentive is something of value given to change behavior or sway a decision. What is a bribe? Something of value given to change a decision or change behavior or sway a decision of a public official. It's the same thing. An incentive is a bribe. If it's given to a public official, it is a bribe. See, they try to treat it like a corporate money, like a corporation. They try to run it like a corporation. They said, we'll give our employees incentives to establish more cases. Well, guess what they did? That's a fucking bribe. You're a public official. You swore an oath to the Constitution. Where's your anti-bribery statement that you likely do not have? CPS worker, do you have an indemnity statement stating that you're not going to commit fraud? Where's your oath of office? Because last I checked, CPS workers are public officials. People enforcing child support are not, though, because under cooperative arrangements, 45 CFR 302.34, they descend to the level of a private contractor, a private person. 42 USC 659 I4. That's under B. They do not get immunity to your 1983. But yeah, so 42,666 and 616 are a violation of my religious liberty, and they did that under the state plan, which means it's premeditated deprivation of rights under color of state law, which means I can motion for summary judgment. And my summary judgment, I want any and all case dismissed. I want any and all money paid back to me. On top of that, I want my $250,000 for having to deal with this frivolous matter. And I got Supreme Court case law that established that they can't stop me from these suits. They can't stop me. And they're all in a private capacity as a contractor. I got proof of the contracts. I have the contracts. I have proof that you cannot have criminal elements in a contract. I have proof that you can't violate civil rights with a contract. Unconscionable elements. These are all things that don't impair the obligation. They void it from the very beginning. It's messed up how they do, man. Listen, I dealt with what was 4 years being homeless and living homeless out of my car and everything like that. I'm finally back on my feet. Not to mention I'm disabled, which is on a case closure criteria, and they shouldn't even be coming after me anyways. And then I'm having to witness people get their kids taken away unlawfully by state intervention on some disgusting shit, and I have to witness this. Nah, man, I should be able to sue for having to witness this. This is a conspiracy, man, and conspiracy is a crime. And look, If they continue committing peonage, guess what? If they knew it was wrong and they did it anyway, they can get a life sentence out of that for kidnapping you and taking you to a jail cell, especially if you're out of state. 18 USC 228. This is all memory. You get me in a trial, this is all going to be memory. This is not, I don't need documents. I don't need none of that. All I need to do is file the complaint. They violated my rights. I'll explain it in court, boss. One motion, summary judgment. Boom. You don't get to make no defense. This isn't a criminal trial. You don't get criminal defenses of having witnesses and all this other stuff. You don't get to. I do. You violated my rights. You falsely imprisoned me. You coercively incarcerated me. And you deprived me of 3 years with my child, now going on 4 or 5. And I'm going to kick you in the behind for that. You can guarantee it. I'm taking them all to court. Baby mama, you are accepting the proceeds of extortion for cooperating with the child support agency. I hope you like a ship up 3 years in prison. Not to mention, you violated your own custody arrangement because I had parenting time and you didn't let me have it. And that's illegal under Michigan compiled laws. Y'all unlawful state actors, you know where I live. Why don't you come get me? You know how many men I've had to hear their case? I haven't seen my son in 3 or 4 years. This is disgusting. Despicable behavior. If we can't make the money off of the child support, we'll just make it off of the backs of the adoption centers and the foster cares and everybody else that we had and guardian ad litem's, and we're adding these administrative law judges. We got to put in the federal parent locator servers, and we got to make sure everybody's following their obligations to their rights that we don't have any business obligating them to because they're their rights. Sounds kind of bass-ackwards, don't it? But I got to get out of here, folks. I don't mean to be argumentative with anybody. Although you are correct, that's how they make it look like on paper. That they really do make it look like that. But it's not real. That's not a real court of law, y'all. That is not a real court of law. That's an administrative function of the executive branch. It's a violation of the separation of powers doctrine to even have you in there. But I'm out of here. Jonathan, if you need it's Mr. Obsidian 8009. You can go find it on YouTube. Go to my Deep State Museum. I feel like you would love that stuff. But I'm going to get on out of here, y'all. Y'all have a good night. Please support Gunner. He's coming on next for his show. He promises to have a pretty good show tonight. Lord, I just like to thank you for the fellowship of having the families here tonight and having everyone on board with this fight that we're fighting. And just, it's hard. I'm just praying for the kids, Psalmate 2. In Jesus' name, amen. Have a good night.
Be back in a little bit. Okay, I'll be back with your salad.
No.
Which companies are you guys going to?